Ltd and Clarkson and others.
Good afternoon, my lords, my lady.
Yes, Mr. Bowles, is it?
Sorry, madam.
Mr. Bowes.
No, it's Mr. Buck.
Mr. Buck?
Yeah.
Oh, all right. Well, just before we begin, can I tell you how we're thinking that the hearing might go? Let me first tell you what we've read. We've read the skeleton arguments. We've read Judge Hodge's judgment of the 10th of February and the post-judgment transcript. We've read the amended defence and Part 20 claim and Taylor's letter of the 3rd of February, which is the explanation relied on as we understand it. We've read the proposed re-amended defence and Part 20 claim. We've read the settlement agreement. We've read Mr. Clarkson's witness statements of the 6th of August 2019 and the 4th of November 2019. The application to enforce the Tomlin order of the 25th of October 2019 and the draft particulars of claim that were produced at around that time. We've read the judgment of the 11th of November 2019 and the order of the 8th of November 2019. And the way that we had envisaged the hearing proceeding is to hear what are called the admissions appeal first, both sides, followed by the abuse of process appeal, both sides, followed by the conspiracy pleading appeal, both sides. So you can take it that we know what the case is about and the various points that need to be decided.
Thank you, my lord. I've had very useful discussions with my learned friend in respect of a potential alternative, as it turns out, arrangement, which if I could just explain both our positions,
yes,
these agreed positions. Fundamental points on appeal are not that complicated.
No.
There's no real difference between us in respect of any legal submissions.
No.
The difficulty is that the matter is very complicated in respect of the chronology of events, both factually in respect of the underlying proceedings and also the proceedings themselves. And what myself and my learned friend considered was maybe appropriate was for us to, or for me, to set out that chronology of events from day one, essentially. So
what are the underlying transactions you're talking about?
Well,
or the procedural chronology?
Both. The reason why the underlying transactions and the characteristics of what was going on is important because that then, I certainly say, affects how the court understands the steps taken by Mr. Clarkson, for example, in respect of abusive process.
But it's all in the skeleton arguments, isn't it?
Well, it is, but there's an awful lot of detail within that, and obviously we were mindful that this is appearing at first instance to be quite complicated to understand both aspects, and I think we're both with the view.
Well, the points in issue on appeal are not that complicated.
No,
in that respect.
Accept that. I do accept that, my lord. Obviously, the idea was to try and cut down on the actual substantive submissions on appeal, and we did come up with a proposed timetable to reflect this. Obviously, we're in your lordship's hands as to how you wish us to.
Well, I think our preference is to deal with the issues in the order in which I've just described them.
Thank you, my lord. The only one missing was interest. I don't know whether.
Yes, that
I appreciate it.
That really comes in as part of the admissions appeal, doesn't it?
Yes. Well, then I'll sit down, my lord. Unless I can assist further at this stage. Can I actually, forgive me, do apologise. Can I just address the court in respect of representation?
Yes.
Because there is an issue in respect to Mr. Glenn Thomas.
Yes.
Which the lordship might not have.
No, don't think I'm aware of
that. So just obviously in respect of my client, I represent all of the Part 20 defendants we are learning from Ms. Lukova. Mr. Bowles represents Mr. Clarkson and also what's known as the MC Defendants, apart from Mr. Thomas. That's Glenn Thomas. Mr. Thomas.
Is he's now...
He's bankrupt, my lady, yes, that's correct. So there was a bankruptcy order of the 23rd of March, which those instructing my learned friend were not aware of. That's a bankruptcy which took place obviously after the hearing before His Honour Judge Hodge, and also after the filing of the appellant's notice. The official receiver is the trustee in bankruptcy, and the official receiver's position as set out in correspondence of Monday is that they are not pursuing the appeal on behalf of Mr. Thomas.
Yeah.
And Mr. Thomas has also declined to acquire any rights in respect of the proceedings. There is a letter to that effect.
Yes.
And therefore, on that basis, Mr. Thomas's appeal does not proceed. Obviously, we still have appeal in respect of an order which affects him. And obviously, my learned friend doesn't appear on behalf of Mr. Thomas.
Do you need our permission to continue with the proceedings against a bankrupt?
No. No. On that basis, I'll leave my learned friend to address.
Yes, Mr. Bowes.
My Lords, my lady, thank you very much for the indication how to proceed today. In terms of the substantive background, and given the wealth of material the Court's indicated that it's read, I don't propose in those circumstances to basically take my learned friend's hat and to run you through the background.
No,
it sounds like that would be a waste of everybody's time.
Yeah.
And I wholly accept the points, in essence, on appeal are simple. Dealing to start with then with what was ground 2 of our grounds of appeal, which, my Lord, you referred to as the admissions.
Yes.
Our submission, in a nutshell, and you would have seen this from the skeleton arguments, is that in essence His Honour Judge Hodge fell into error by not allowing those admissions when they were sought at the hearing.
Yes.
And we say there are two admissions in particular. Those are the ones that paragraph 26, subparagraph 4, relating to a Mr. Boswell, and paragraph 26, subparagraph 7, to Mr. Unsworth. They are in respectively £124,000 and £860,000. I wouldn't propose to take you to that particular point of the amended defence at this stage. I don't think it's necessary unless I was given an indication.
No, we've read it.
Our submission, in a nutshell, on behalf of the MC Defendants, but obviously not in relation to Mr. Thomas, is that the admissions themselves were drafted in error, and you'll have seen that was put forward in the 3rd of February letter by Taylor's solicitors. And that explanation was provided to the court. That 3rd of February letter was in a bundle before the court.
Well, can we just unpack that a little bit?
Of course.
I mean, all three of us have practiced at the bar.
Of course.
Solicitors instruct counsel to settle a pleading.
Indeed.
And counsel does that. And let's assume, for argument's sake, that counsel has misunderstood his instructions. The settled draft goes back to his instructing solicitors, and one would expect somebody to check it.
Indeed.
Perhaps more to the point, somebody then verifies the draft, the engrossed draft, with a statement of truth.
Well, correct.
And a false statement of truth carries with it potential contempt penalty.
Indeed.
And then the pleading is amended, and somebody again verifies it with a statement of truth. So it can't possibly be enough to say that it was counsel's mistake, because at least 2 people, that's one person twice, signed a statement of truth. And the 3rd of February letter says nothing at all about that.
My Lord, no, it simply relies on counsel's favour.
Indeed it does. Not only that, but where a pleading is verified by a statement of truth, which itself has evidential weight, one might expect something of at least equal evidential weight to contradict what is verified by the statement of truth. And a letter doesn't do it.
My Lord, I accept the letter is not verified by a statement of truth, and that it's not in any meaningful way evidence before a court.
Yes.
I have to accept all of that.
And that was part of the reason that Judge Hodge gave. He said there's no application, which is true. There was an application to amend, although it purported to be by consent, which it plainly wasn't. But there wasn't any evidence before him leave aside the letter, there was no evidence before him to explain how that series of mistakes came to be made.
Well, look, I have to accept all of those points. That's just true. However, in my submission, and this is where we come into the slightly unusual circumstances of what happened at the hearing in front of His Honour Judge Hodge on the 8th of February, and why we actually say that is relevant. Now, my lords and my lady, I'm sure you picked up the fact that at that stage the funding was only available to instruct Mr. Cogley QC to attend in relation to what I think turned out to be about a half day's argument about continuing the freezing injunction. Mr. Cogley then bowed out of proceedings at that stage, leaving a slightly curious situation where you had Mr. Clarkson, who was attending via the remote link, supposedly representing all of what we are now calling the MC Defendants. Those, in whatever capacity, they were certainly litigants in person. Mr. Clarkson is not a legally qualified person. His rights of audience, insofar as a point I've made in my skeleton argument, how he could be representing the other MC defendants is slightly questionable, given the fact that he couldn't really be standing up to represent them in any meaningful way. But the reason we say this is important is because, to some extent, it explains why His Honour Judge Hodge appears, and I have to say appears because we don't have any positive evidence either way, to have been addressed directly in relation to the 3rd of February letter. Now, my lord, I accept your point is, well, even if he had been, it wasn't going to be good enough. Yeah. But my lord, I think in my submission, if one, what I proposed to do in my submissions was to take you through part 14 and the practice direction, but I don't see that there's going to be much point in that. I think we've hit the nub of the issue.
We have.
But my lord, and the reason we say it's important that His Honour Judge Hodge wasn't taken there is when one looks at his judgment, and in particular, it is paragraph, I think 74 of his judgment.
Paragraph?
I think it's 70.
17?
It's tab 17.
Yes.
And then he deals with the admissions.
74 is still dealing with abuse.
Paragraph 1.
Which paragraph?
Yeah, paragraph 134.
134.
134 is the key as far as we...
So he says there's no application, that's true, or any explanation, you say that's not true. No formal application to withdraw has been made, that's true. And in the absence of such, the application must fail. No witness statement, no witness evidence, no proper basis.
My lord, yes. So those are Mr. Buck's submissions, and he then says, I accept those submissions.
Yes.
On the second last line. But then we say the key sentence is, I will not give permission in the absence of any explanation with the withdrawals of these admissions. Now, my lord, we have a point in relation to the procedural elements, the absence of an application. And this is the point that in my skeleton argument I referred to as the court not wanting to indulge in an overly formalistic view. The point is, in my submission, that on the 28th, but there was an application notice made. There was an application made. It was to amend the pleadings. It stated to be in terms of Part 17. Part 14 requires permission. Part 17 would also require permission at this stage in proceedings for any amendments to be made. So in essence, the court was going to be looking at exactly the same thing. Should it be granting permission? Therefore, in my submission, His Honour Judge Hodge was not quite right to say there was no application before him. The application notice didn't say CPR 14 applies and the practice direction applies, but it did say we would like to amend and we would like to withdraw these admissions. Now, I accept that it says it was by consent when it wasn't. Certain admissions had been
Yes.
by consent. So in relation to that procedural point, we say His Honour Judge Hodge was wrong to say there was nothing there. Now, I have to accept that the only evidence the court has ever seen in relation to this, signed by a statement of truth, is a witness statement of Mr. Cattrall, which comes on the 10th of March. That you have that in the bundle, but it is after the hearing. And I have to accept that. I cannot criticise His Honour Judge Hodge for not having seen that. But it is in evidence, and it refers to the chaotic manner in which the pleadings were put together. My lords, I can take you there, my lady, I can take you there if it would assist. But the key point we say is that in circumstances where There is an explanation.
Well, just as a moment before you start taking us to post-hearing evidence,
Right.
you have to satisfy a Ladden-Marshall test to get it in at all, don't you?
My lord, I wasn't proposing to take you there because I can't satisfy Lad, and I had nothing before you to suggest that I could satisfy Lad and
Yeah.
Marshall, and so I'm not going to. I can say that an explanation was provided after the event. I accept that for His Honour Judge Hodges.
The only trace of an explanation that we have that predates the judgment is the 3rd of February letter.
My lord, yes.
And I think you've accepted that that letter doesn't provide an explanation.
Well, my lady, I say it provides an explanation. Now it blames it on counsel.
Yes, but as my lord has just put to you, on 2 occasions, somebody verified those pleadings with a statement of truth, and it doesn't explain that.
My lady, it doesn't. The letter is scant in its detail. The reason that is put forward for that, has been put forward for that, is that without waiving privilege into the instructions given and the back and forth in the pleading process, it has not been possible to provide that. And that is the explanation that has been put forward. That's the submission I make before this court. Whether you simply say to me, well, it's still not good enough.
Well, that's not really the question, though. The question for us is, was Judge Hodge wrong on the evidence, either that, or on the material, either that was in front of him, or which might have been in front of him at the time when he made his decision? And the highest you can put it is that what might have been, or perhaps what ought to have been in front of him, is the 3rd of February letter.
My lord, that's the highest I can put it. That's the highest I do put it. Certainly not trying to go any further than that. But what we do say is that in the context of some unrepresented defendants, now I accept that Mr. Buck has put in right hassle and all the authorities one would expect to see, and I accept that litigants in person should not be put in a different position
Well,
to any
but
other.
hang on a minute. The letter was not written by litigants in person. The letter was written by solicitors representing the litigants at a time, I assume, when they were properly instructed by the litigants to write that letter. And they wrote what they wrote, and nothing more.
My lord, that's right. We are stuck with the letter, and I'm not trying to get past that.
No.
What I'm trying, I think the submission that I'm trying to make, and fairly ineptly doing, is what I'm trying to say is that the crux of His Honour Judge Hodges' decision was, in my submission, I haven't been provided any explanation at all. And we say that had he been provided with sight of the 3rd of February letter, or even if he did see it, because we don't know for certain whether he did.
Let's assume he did see it. How would it help? You've accepted it doesn't explain.
Well, my lady, we would say it would have been sufficient for him at the hearing to say there is enough of an explanation. Now, it blames counsel. It doesn't provide any detail behind that. I have to accept that. I'm not, I know what the letter says. We all know what the letter says. But the simple...
But you have to go a bit further, don't you? You have to say he would have been wrong not to have accepted it as an adequate explanation. Not that he might have accepted it.
No, my lord, to succeed on the appeal, yes. And we say that he would have been wrong not to accept it. We say that, in essence, the explanation in the letter, as scant as it was, would have been sufficient to tick the box of an explanation. And it would then have been for His Honour Judge Hodge to consider the factors set out in the practice direction to Part 14, Paragraph 7, which ends up with, in essence, a weighing of, to some extent, a weighing of prejudice. Now, my lords, you'll have seen in the authorities put forward, and my learned friend and I don't differ on the law, the Paragraph 7 criteria are not hierarchical. They should all be treated equally. And what I sought to set out in my skeleton argument, and what we put forward now, is simply the position that the explanation is one of those factors. Had His Honour Judge Hodge looked at that explanation, we say he would have said, well, that's sufficient. We then say he would have looked at the balance of prejudice and said, well, the prejudice caused to the 2 particular MC defendants, or to the MC defendants, who are admitting something that they now say they shouldn't be admitting, to the tune of just less than £1 million. That is a substantial prejudice to them. How does that weigh as against the prejudice caused to Asertis, the claimants? And now, of course, I have to accept that the test for prejudice is not have Asertis got a windfall by this withdrawal. It's a question of are Asertis worse off if the court had allowed the withdrawal? And they plainly would have been. So they would have been prejudiced. But the question is the balance of who would be more prejudiced. And in my submission, there is only one answer to that, which is that it's the MC Defendants who...
That might depend on exactly what the explanation was.
Well, my lord, given the limited explanation that we do have, and in the context of a hearing where, well, my lord, that is in a nutshell our point, is that had it been put before His Honour Judge Hodge, he would have said the explanation is sufficient, and he would have said, I must now go on to consider those other facts.
Would he not also have had to consider what the relationship was between the non-admission being put forward and the admissions of all the receipts in Schedule 2A, I think it is? To
Yes, Annex 2A, my lord.
And to ask himself, well, what is the positive case being advanced by which somebody who receives money is not liable to repay it? Is it said to be a gift, or is it said to be... What is it said to be? What is the relationship between what continues to be admitted on the one hand and what is now not admitted on the other?
My lord, yes, but of course, when we are talking about a withdrawal, it's a withdrawal in terms of the MC Defendants. There was still admission that MC, Mr. Clarkson himself, my client, would have been liable for those sums. And it is quite clear from Annex 2A, when one looks at it, and from the pleadings, that there was a setup, it appears, where sums were loaned for Mr. Clarkson. Now he is accepting, would accept, even with those admissions, would have accepted liability. And that would have been another factor in His Honour Judge Hodge weighing the prejudice, which is this is not simply going from £1 million of admission to £0 of admission. It's simply who is making the admission. And that is actually, perhaps to some extent, where the complicated nature of the pleading and the dealings which the pleadings give rise to or shine a light on can to some extent explain how counsel could have made a simple error. Now I accept that there is then at least a two-stage review process which goes on. Solicitors look at it and then the clients will have to sign statements of truth. And that happens twice. I accept all of that. I have to accept all of that. But in my submission, if one were confronted with the explanation such as it is in the 3rd of February letter and then considered the other factors set out in Practice Direction 14, paragraph 7, we get to a point where we say His Honour Judge Hodge would have allowed the admissions to be withdrawn. Yeah. And that, I mean, that really is our case.
Right.
I don't wish to repeat anything. The points you've seen in the skeleton I made about the way in which the letter wasn't put before the judge or not put before the judge. But of course I accept that one has to focus on the vision. Had it been put before the judge, would he have been wrong? Yeah. Would he have been right? What would he have done? So, my lord, perhaps unless I just turn my back to check that I've not missed anything out.
Thank you very much.
All right. My lord, those are our submissions on that admission point. In terms of, would you like to address the interest?
Yes, by all means.
My lord, in relation to the interest point, it's a very short point. There are two relevant clauses, and you've got the two agreements. They're in the very back of the core bundle. There are two funding secure agreements. They're pages 421 and 434.
Sorry, can you say those again?
Of course, my lady, forgive me. It's in core bundle, it's tab 26.
Thank you.
That is the first of the agreements. That relates to Mr. Unsworth.
Yes.
And my lords, the important points are in sections 1 and sections 2. Section 1 is mostly, that's on page 423, sets out the rate of interest. It's the definition section of the funding secure agreement. Sets out a rate of interest, sets out an arrangement fee of nil, and then sets out an administration fee. And it's really the battleground is around the administration fee, my lord, where it says if the borrower fails to repay the loan on the repayment date, the administration fee will continue to be charged at the rate specified until the loan and all other sums outstanding under the agreement are repaid in full. My lord, the second area to take you to is clause 8, which is called default fee. You can see that it's the very bottom, page 424 is the heading, And then over 425, my lords, my lady, is the wording itself.
Yeah.
Where it says, if the borrower fails to pay any amount payable by it under a finance document on its due date, a default fee shall accrue on the overdue amount from the due date up to the date until actual payment, both before and after judgment, at a rate which is 0.5% per calendar month higher than the administration fee, which would have been payable pursuant to Section 1. And then it goes on to say, if the overdue amount had, during the period of non-payment, constituted the loan, any default fee accruing under this clause should be immediately payable by the borrower on demand by the lender. Now, the way this matter came before His Honour Judge Hodge, this was, and my lord, we can see this in the Day 3 transcript, which is in the core bundle. It's page 215 within tab. It's tab 18. And you can see, my lord, that in essence what we've got is the discussion following money judgments being entered. Mr. Buck says, my lord, and then the order will record various monetary judgments against the MC defendants.
Sorry, which page you want?
Sorry, 215.
215. Yes?
So, my lord, we also seek, as per my submissions earlier, the entitlement to contractual interest in respect to the two specifically identified arrangements. Yes, that must follow as well. It then, from in respect, in my submission, it looks like that actually is Mr. Buck's submissions, which have been wrongly accredited to His Honour Judge Hodge. He sets out that the third witness statement of Mr. Brew deals with this. And my lord, you've got the third witness statement of Mr. Brew in the tab 24 in the linked appeals, in the 505 appeals bundle. And it's the point that we make from the passage I've just taken you to is there is no argument on this point. My learned friend has taken point to say this is a point that was never argued, never really put before the court. In my submission, this was in essence being dealt with at the very end, or towards the end, on Day 3 of the hearing, after judgment's entered. Yes, there's got to be some interest on that as well. And His Honour Judge Hodge then refers to the fact that those were based on supposedly admitted figures. And we can see that, I believe it's...
Yeah.
Well, I think it may well be in His Honour Judge Hodge's order where he refers to it being based on the admission. My lord, yes, it's on page 166, tab 12 of the core bundle. It's where the two interest rates are actually put into view. It's paragraph 12b.
166, yes.
166, and you'll see at B, little Roman 1 and little Roman 2, a reference to the interest rate, and then based on the admission at paragraph 50 of the MC Defendants Amended Defence. Now, my lords and my lady, the paragraph 50 of the MC Defendant, the Amended Defence, we have a number of versions of the Amended Defence in the bundle, but if one goes to the version which we have at page tab 23, 305, which is just the amended defence, not the re-amended defence, and one goes to it's admitted that the former claimant entitled to interest on loans.
Sorry, which page?
Sorry, page 320. Forgive me. And that's tab 23.
Yeah. So the admission is either in accordance with the signed loan agreements or pursuant to section 35.
Indeed. The admission is only, it does not admit the rate. And that's why Mr. Buck then took His Honour Judge Hodge to the witness statement of Mr. Brew, the third witness statement to Mr. Brew. And my lords, I don't know whether you've had a chance to read that statement. It sets that the interest rates out at paragraphs 30 and 35. That is in the 505 appeals bundle.
505. It's quite difficult keeping track of which is which.
My lord,
I've got a consolidated core bundle.
Yeah,
so there should be a consolidated core bundle.
Supplemental bundle?
Supplemental bundle.
For 505, all right.
Indeed, and then they're slightly unhelpfully, the other supplemental bundle doesn't refer to what it relates to, so I've simply been referring to that as the linked appeals bundle. I think my learned friend is
All right, so they're going to Mr. Brew's witness
Mr. Brew's third statement, my lord, which you have at tab 24, my lady, at tab 24 of that, and then he sets out contractual rates.
Yeah.
He claims the contractual rates to be at paragraphs 30 and at paragraphs 35.
Yes.
Now, my lord, as you would have seen, in essence what we say is Mr. Brew slightly overstated the position. We say that the...
You need to look at paragraph 28 as well, don't you?
Sorry, my lord, paragraph...
Sorry, page 138.
My lord, yes. Sorry, I've taken you to where he had applied the interest. Yes.
Yeah.
My lord, what we say is when one goes back to those funding secure agreements, we say that's how His Honour Judge Hodge fell into error. He was led into error by we say a mistake by Mr. Brew. That's because Mr. Brew added not only he added the default interest rate as well as the further sums in.
So what happens here is that Mr. Brew makes a witness statement on the 2nd of October.
Yes.
It's about 4 months later that Judge Hodge decides the application. And there's no contradiction of Mr. Brew's evidence from anybody on the MC Defendant side. Is that right?
My lord, that's right. My lord, that's right. It's a point that's taken on appeal. It's not a point, in my submission, the reason I took you to how it was dealt with earlier in the proceedings. Now, I accept that up until a few days, in fact, until midway through the hearing, there was representation for the MC Defendants. That was, however, on a very limited basis relating purely to the freezing injunction. I have to accept that there was before that.
There was limited representation by counsel, but tailors were acting.
Well, Taylor's came off the record on the 8th of February as well.
Yes, but between the 2nd of October and the 8th of February...
Oh, of course I accept that. I have to accept that there is a resounding silence. I can't get past the fact that there is a silence this is not a point that is dealt with. But my lord, we say when one looks back at those facility agreements, Mr. Brew, what really should happen is that the default interest rate should no longer apply, and it should be replaced by the interest rate at clause 8. What Mr. Brew has done is he's maintained charging a default interest rate as well, which has given a step up of around 6% or 6.24% in each case.
What's the error by the judge? He didn't have any submission or evidence to contradict what Mr. Brew said.
My lady, no, but...
So what's his error?
Well, by simply taking Mr. Brew's witness statement at face value and not analysing the...
Nobody told him not to.
My lady, I accept the reason I took you to the point I was trying to make earlier when I took you to the transcript is how this was done almost as a necessary bolt-on. You know, except Mr. Clarkson was there.
Yes.
I can't...
I mean, the judge is a referee, not the goalkeeper.
My lord, I accept that, of course. But in circumstances, again, this comes down to the slightly unusual way the hearing was unfurling. And in circumstances where the contractual interest rate was simply being dealt with between Mr. Buck, in my submission, the error was for the judge not to look at the interest rate and not to then see at clause 8 the reference to that this would apply in place of, we say the clause 8 interest replaces the default.
No, I understand that. I'm bound to say, I think if I had found myself in the position of the judge with evidence that had stood uncontradicted for 4 months with the calculation of interest, honest, and at least one of the parties in front of me, not disputing it, I wouldn't have been concerned to work it all out again for myself.
Well, my lord, perhaps not to work out the maths, as it were, but the principle of the interest, I think, is our point. I don't think anybody's suggesting that His Honour Judge Hodge should have sat there and actually worked out the figures. That's very much for counsel to do whilst drawing the order. But in my submission, the principle, the error he fell into was not considering the clause. And had he done so, we say that the wording of clause 8. I only
Well,
took...
do you have to say? Do you have to put it that way? Do you have to say the error the judge fell into? Because that's picking up my Lord Justice Lewison's point to you. You know what? To say the judge fell into error is a bit harsh on the judge. You have to simply say that the decision was wrong, don't you?
Well, yes, I think that
Which
may
isn't
well-
the same
my lord,
necessarily.
my lord, it's not necessarily the same. And I think perhaps that may be the key, is that the decision was wrong. This court can see...
I mean, what you're saying is the decision was wrong by reason of a point which nobody made to the judge. Is that right? I mean, is that what you're in essence saying?
My lord, in essence, but and the way I explain away, or try to explain away, the reason the point wasn't made to the judge is by, again, going back to the unusual way this case was put in the way at this point, Mr. Clarkson, whilst he was in attendance, these are for two of the individual MC defendants. They are not corporate entities which he...
Yes, but at the moment I'm just trying to identify what tests you have to surmount to succeed. And the point's being made to you that it's very harsh to criticise a judge for erring, getting wrong, something which was never put to him. If you say, did the judge made a mistake, but is that what you are actually saying on appeal? Are you not saying that the decision was wrong, but by reason of a point not made, which this court could correct? I mean, that's what in essence...
I think that probably is a far neater way of putting my submission than I've been trying, and it is the way we've put it in our skeleton argument, and is the way we've put it in our grounds of appeal. And perhaps I've not been making it very clear today, but that is the point. It is. We say it is wrong. I accept that a judge at first instance, at the end of 3 days of this case, can't really be criticised. I don't criticise His Honour Judge Hodge for not having looked at the nuts and bolts, but the point is it is wrong, and we say this court should be correcting a wrong finding. My lords, those are my points on the interest point, unless I can assist any further.
Ingrid, anything more? Thank you very much, Mr. Bill. Yes, Mr. Buck.
My lords, my lady, just if I could continue with the issue of interest first before reverting back to admissions, and just because we're there. In respect of the interest, my lords, ladies, you picked up on the point that there was an application made on the 2nd of October for summary judgment. Within that application, there was a claim for the contractual interests and fees due under the two facility agreements. That claim was set out in full within the accompanying witness statement of Mr. Brew, the third witness statement, which the court has been taken to. The court has also, as my learned friend confirms, it is the position there was simply no response whatsoever to that argument, either in witness statements or in correspondence. And that was in circumstances in which on the 4th and the 5th of February, a total of 5 witness statements were filed on behalf of Mr. Clarkson and the MC Defendants. And it was also the case that throughout that period, tailors were on record for those parties, the MC Defendants, in respect to the proceedings. My learned friend makes reference to how the matter was dealt with at the hearing. And obviously, we don't have the benefit of the transcript from day 1 and 2, but one can see in any event that this was the subject of submissions, because if you look at the passage that my learned friend has taken the court to on day 3, there's a reference there from me to earlier submissions.
page 215E.
Thank you very much, my lady. Those submissions took place post-judgment, and if one looks at the judgment itself, you can see within the judgment that the court, His Honour Judge Hodge, did deal with the issue of interest. That's at page, behind tab 17 of Core Bundle 1, tab 17, page 204, paragraph 138. So my clients had set up their position on this issue within Simon Brew's third witness statement. It had been set out also within our skeleton argument for the hearing, paragraph 99, paragraph 100 in fact. The court will see from the judgment of page 138 that it was dealt with in the sense it was referenced, and you can see on the penultimate line further submissions.
So can I just, I think I've missed the reference somewhere en route. Your skeleton argument.
Our skeleton argument referenced the issue of interest. That reference for the skeleton is in the linked supplemental bundle, tab 24, page 288.
Tab 24. Yeah, para 99 you're getting at. All right.
And also paragraph 100, referencing Simon Brew 3.
Yeah.
Yeah, but that doesn't really advance matters very much, does it?
No, but I'm explaining how this issue of interest was raised as it should have been, both in witness evidence before the hearing, as to setting out the basis of what
Yeah, so you say that it's calculated in Brew 3.
Yes. It's addressed in skeleton arguments, which were, according to Mr. Cogley of Queen's Counsel, received by the MC Defendants. There's a reference in the note of a journalist taken of what was said on day one, where that's recorded, because there is an issue in respect to representation. It's then referenced by His Honour Judge Hodge in his judgment.
Yeah, it's paragraph 100. I think you
Yeah, so 99 and 100. Yeah.
Yeah.
I mean, we weren't going to simply repeat what was set out in Mr. Brew's witness statement. And then post-judgment, there were further submissions made, and you've been taken to those further submissions, where at no point...
Yeah, well, your point is that Mr. Brew set out his calculations and no one contradicted. But Mr. Bow's point is, well, Mr. Brew got the interpretation of the agreement wrong.
Well, on that point, there's two potential interpretations. Mr. Brew took one interpretation. It was a dispute to the extent to which it was a dispute, and we don't accept it was a dispute before His Honour Judge Hodge, because it wasn't raised as a dispute. There are two different interpretations. One put forward now by Mr. Bowles at this hearing, and one put forward by Mr. Brew in his witness statement as to how the sums were to be calculated.
So you don't accept it's wrong?
No.
Are you saying two things? I mean, if it was wrong, suppose we take the view it is wrong, are you saying that we can't deal with that? You are saying that.
It was not a point put forward before His Honour Judge Hodge. To the extent to which there is a dispute now, it's one of contractual interpretation. We do not accept that the interpretation put forward is the correct one.
Right, but what else would we need to interpret the contract that you've just been shown?
Well, my lords, it's a question as to whether His Honour Judge Hodge has erred and fallen into error.
Well, no, it's a question. Isn't it a question of whether the decision was wrong?
Well, retrospectively, decisions might be viewed as being wrong, but that, I would submit, is not the basis to overturn.
But that is a CPR test for what the court can do on appeal, isn't it?
I do appreciate that, my lords, yes.
The decision was wrong. I mean, people do take new points on appeal.
fully accept that, but that's in circumstances. My lords, it's a question, my lady, as to whether you obviously consider it appropriate to interfere in respect of an order that's being made.
Well, the first question, I suppose, is do we allow a new point to be taken where it is one of contractual interpretation?
Yes.
And I don't think you have said, have you, that had the point been taken below, there would have been different evidence called, for instance? Mr. Bew's evidence was his evidence.
Yes, I don't say that there was any requirement for further evidence. That's accepted.
Yeah.
But on that point,
I mean, the course of the trial, or the course of the hearing, or anything else wouldn't have been any different. I mean, I think I certainly said that when you're deciding whether to allow a new point to be taken on appeal, which ex hypothesi has not been taken below, let's assume it's a new point. There's a spectrum of possibilities. One is that it would have led to the trial taking a completely different course below, where extra evidence would have had to have been adduced, and new argument and everything else. On the other hand, it's a simple point of contractual interpretation, which requires no additional evidence other than the contractual clauses which are in front of the court.
the only thing I would add into the situation is that there is reference to submissions having been made previously. Now, it's difficult. I don't want to obviously lead any evidence as to what was said, because there is no transcript of what was said on day 1 and day 2. But there is reference there to previous submissions having been made on that point.
Well, okay, but
So it might be the situation in which that point was aired in submissions.
okay, but I mean, in a sense, best case for you is that the point was never taken at all.
Well, quite, yeah.
So, on that hypothesis, are you still saying that we can't look at it given that there's no additional evidence required, and it's a point of interpretation of two clauses which we've been seeing, unless you tell us that there are other clauses?
No, those are the two clauses. And what we say in respect of those two clauses, if one was to have the argument on contractual interpretation, is that the wording in respect of the application of the arrangement fee is clear.
But are you accepting that we can have that argument?
No, I'm not accepting that.
But why, if there's no need for evidence and the trial
well,
would have taken a different course?
I say submit that you shouldn't do that in
Why?
circumstances in which the point wasn't taken for 4 months.
But
Well, until this point of
courts
trial.
on appeal can entertain new
Yes.
points, but not where evidence would be required and the trial might have taken a different course. But you're accepting that, isn't that?
I accept that as a principle that the court can if it so wishes. I'm saying that the court should not do so, should not exercise that discretion to look at the point.
Why?
Because of the fact that it was an order, it was a point first raised, as I say, in October 2020. It was a point for which there was no response whatsoever. It's a point that my clients have secured a judgment on in respect of that sum, and now is faced with an argument not raised before, when there's no good reason for it not to have been raised before, in circumstances where it would therefore be prejudiced by losing that benefit of that judgment.
Your construction argument, I suppose, is that the interest rate administration fee and the default fee are cumulative.
Yeah.
What meaning do you give to the words which would have been payable, pursuant to section 1?
I don't dispute that there's a degree of ambiguity between the wording within clause 8 and also the wording within the definition of administration fee. Because similarly, in respect of administration fee, if the borrower fails to repay the loan, i.e. therefore falls into default on the repayment date, the administration will continue to be charged at the rate specified until the loan and any other sums outstanding under this agreement are repaid in full. So within the word, if one was to look at the administration fee and say, does that, and putting aside the issue of clause 8, does the administration fee continue to accrue? Then the answer would be clearly yes.
Well, wouldn't it have to say, instead of saying which would have been payable, what you're saying is it means which is still payable?
That would assist
So
in clarifying the position.
So we need to read the words which would have been payable as which is still payable.
Well, that paragraph, if the borrower fails to repay the loan, so that is envisaging a situation of default. So the wording within, as contained within the definitions of administration fee, is clear in that respect. That is a fee that doesn't just that continues post default.
No, but the relevant question is the default fee is what comes in if the borrower fails to pay an amount due under the finance document on its due date. So you look to see whether the default fee is due and payable, and what it says is there is a default fee at a rate which is 0.5% per calendar month higher than the administration fee, which would have been payable pursuant to Section 1 if the overdue amount had, during the period of non-payment, constituted the loan. So
I'm not disputing that there is a tension between Clause 8 and the definition of that fee which is being paid, and also the administration fee. I'm not disputing that there's not a potential conflict between the two, and this is why I say it is a question of interpretation between those two different.
but if the draftsman had meant, if the draftsman had meant to have the administration fee and the default fee both payable simultaneously together in addition to each other, he would have bound to use different words, wouldn't he, in Clause 8? In fact, precisely the opposite words.
As I say, I fully accept those alternative interpretations. Our position is that the administration fee as defined is a fee that is due post-default, because otherwise the entirety of that part of the definition has no purpose whatsoever. So surely when the draftsman was drafting this, there was an intention for that administration fee to continue to be applied. And the unless I can insist any further on the interest.
Thank you.
My lords, my lady, in respect of the issue of withdrawals, I don't know whether there's any specific aspect of that argument that you wish me to address.
Take your own course, Mr. Buck.
Thank you very much, my lord. In respect of the withdrawals of admissions, you will have seen from the pleading that the actual withdrawals of admissions were in a section of the amended defence of the defence, which was appears to have been very carefully drafted. There's a situation in which Mr. Clarkson and his associates have engaged in a series of transactions, if one can call them that, whereby money was removed from and paid out by funding secure. And there is a series of detailed allegations made within the particulars of claim as to the passage of certain monies. The two relevant admissions relate to payment of monies to a Colin Boswell. In fact, it's to his solicitors called Scott's Right, and that can be seen from Annex 2A. And then a series of 7 different payments to John Unsworth. It was against that specific pleading that defence was prepared. My lords, that is a defence that was repeated certainly in 2 statements of case that were verified by statements of truth. And we say in substance, there's never been an explanation provided as to that error that would satisfy a court such that those admissions should be withdrawn. There's a failure to provide the full and frank explanation required. It isn't accepted as a matter of fact that the court wasn't aware of that letter or had knowledge of it, but similarly, that can't be proven, but similarly it can't be proven the other way, that the court was not aware of that letter. It goes both ways.
Well, I think we probably have to assume that Judge Hodge was not aware of the letter, since he says not only was there no witness evidence, he says there was no explanation.
I understand, my lords, yes.
I think we've got to assume that.
But in respect to the letter itself, we submit it would have made no difference to the actual outcome. For all the
Yeah, well,
reasons
that's the
already.
key. That's the key question, isn't it? Yeah.
Unless I can assist further on that issue, therefore, and in respect to the withdrawals, I've got nothing further to submit.
Thank you very
Thank
much,
you very
Mr.
much.
Barker. Yes, Mr. Bowes, do you want to reply?
My lord, only very, very briefly, one point that my learned friend made, which comes down to the tension in the difference between Section 1 and Clause 8. Our simple point is this, and I think it's a point that was put, to some extent, put to my learned friend during his submissions. The drafting in Section 1, in the definition section, lacks the specific clarity that I took you to in Clause 8. The words would have been payable, and we say that is where one can really find the draftsman's intention. Ultimately, that's what we're looking for, and that is where it is abundantly clear. And so, in my submission, this court can and should look at this question.
So you say the words would have been payable mean that the administration fee is no longer payable, but that instead the Clause 8 fee at a higher rate supersedes it.
Exactly, and it's the... If one also looks at what is being achieved by the default rate coming in, it is not to add the same again plus a bit in my submission. The key, and what the draftsman is obviously trying to do, in my submission, is to add the 0.5% or 0.52%, depending which one you're looking at. And that was a point I didn't make clear earlier. These are, whilst they're drafted in the same terms, Section 1 and Clause 8 in both, the rates are different, as you would have picked up from the grounds of appeal. I don't want that point to have got lost anywhere.
No.
But my lord, when one looks at the intention, that is, it is precisely Clause 8 where what is happening upon default, you're being stung with that little bit extra, and that is the rate. It's not cumulative. That is the only very short point I was going to come back on. On that, you have my submissions from first time round, unless I can assist.
No, thank you very much. Right, Mr. Buck, let's go on to the abuse appeal.
Thank you, my lord. In respect to the abuse appeal, the position of my clients is very straightforward in respect of the issue here and the error lines on the Judge Hodge. My lords, in respect of the position between myself and my learned friend, there's no dispute between us as to the law. The question is whether in Henderson and Henderson territory, whether Mr. Clarkson could have pursued his Part 20 claim, and then specifically should have done so.
If Mr. Clarkson were to be allowed to pursue his Part 20 claim, and if that Part 20 claim were to succeed, would it follow that Judge Hodge ought never to have made the order that he did enforcing the Tomlin order? Or is that separate?
Is that, forgive me, I didn't hear the final bit.
Or is that separate? Judge Hodge made an order enforcing, was it Clause 5 of the Tomlin order, requiring Mr. Clarkson to withdraw certain unilateral notices which he'd registered at the Land Registry. On the assumption that Mr. Clarkson is allowed to pursue his Part 20 claim, and it succeeds, is that an order which Judge Hodge should never have made?
Yes.
So you would therefore say, I assume, that the Part 20 claim is a collateral attack on a previous order of the court?
Yes. The purpose of the application made in the Manchester proceedings, which was determined by His Honour Judge Hodge on the 8th of November, was an application to enforce the terms of that settlement agreement by means of an order for specific performance, which was granted. And it was a question, the wider issue at that hearing was whether that clause, and therefore that settlement agreement, was enforceable or not. in respect of the test of could, my lords, my lady, we say that could is simply not an issue here. It's without doubt the case that Mr. Clarkson was aware of the alleged conspiracy, the collusion, as of August 2019.
Well, he referred to it in his witness statement.
Yes. He referred to it in the witness statement in August 2019. He repeated it at the beginning of November 2019. At that point, he had retained counsel.
And she made submissions along those lines for the judge, according to the note.
Yes, quite. Well, there's a different counsel who made those submissions.
Yeah, I'll follow.
Yeah, but those submissions, it was described as a pincer movement to try and take the 10 acres property off Mr. Clarkson. So he was fully aware of the situation. He had the means. His Honour Judge Hodge, in that November judgment, goes through and rejects suggestions that there's been stifling of the ability of Mr. Clarkson to bring proceedings. His Honour makes them.
Does he say that, or does he say it doesn't? It's not relevant. Doesn't reject it on the facts, I don't think, does he?
He said, forgive me,
Supplemental bundle tab 15.
Metal bundle tab
15.
15. Thank you, my lord. He deals with this at paragraph 16 to 18 because he also noted, and it's not within this bundle, but you can see from the judgment at paragraph 16 that Mr. Clarkson, as well as the witness statement of the 6th of August, on the 14th of August, Taylors on his behalf threatened and said they were instructed to issue proceedings.
Yeah.
So which paragraphs were you taking us to? 16 to 18?
16 to 18, yes, my lord.
Not 15. There seems to be something missing between 15 and 16, isn't there?
Yes, looks like it. Quotation from a letter.
Yeah.
So the chronology of events, my lords, just in respect of the post-default on the settlement agreement events, was that on the 1st of March, Taylors, on behalf of Mr. Clarkson, had written 2 letters, one alleging penalties.
Yes.
Secondly, had also alleged duress. There was a threat of duress there, saying that he'd been forced into the agreement and it was therefore voidable for duress.
And what was said to be the duress?
I don't think it went in. I haven't got the letter in front of me, my lords.
I think it's really paragraph 26 that you want, where the submission is made that the lenders had mounted a pincer move to secure a stranglehold on Mr. Clarkson's funds to enable the lenders to be repaid. That's the stifling.
Yes, that's the stifling. That's the knowledge that Mr. Clarkson had of the claim.
And then page 135 in this bundle, in the note of the hearing, she makes the point about money laundering, so she can't put any harm in Mr. Clarkson's statement. So those 2 points were ventilated, if nothing more.
Well, they were ventilated in the context that by that point there had been 2 witness statements alleging this issue of collusion.
Yes.
when the pincer movement.
Yes.
It was clearly there.
And that was in response to your application to enforce a part of the Tomlin order.
Yes. Yes, my lord. So in respect to the issue of could, we say that there can be no doubt that Mr. Clarkson could have brought the allegation forward. And then the question is one of should. His Honour Judge Hodge dealt with this with the finding that Mr. Clarkson had chosen not to do so.
Yeah.
And that's set out in paragraphs 81 and 84 of the judgment. My lords, in circumstances where the principle of Henderson is that the party needs to bring forward their claim essentially at the first opportunity, a choice not to do so can't excuse and can't be the answer to abusive process. Because that's an election by that party. And in the absence of any other...
Well, your point really is the judge thought that was a point in Mr. Clarkson's favour, and you say, in fact, it's a point against him.
It's very simple. Is that he found there was a choice made. That choice is not a defence or an explanation which justifies defeating an argument of abusive process. Hence, there was abusive process, and hence, Part 20 claims should have been struck out.
So really you've got 2 points. You've got, first of all, Mr. Clarkson chose not to advance this case when he could have done, and that's a point against him. And secondly, if he is allowed to advance this case, it's a collateral attack on Judge Hodge's first order.
Yes, my lord.
Is there anything more?
No.
Thank you. Yes, Mr. Bowes.
My lords, my lady, our position on this is that in fact what was happening in November 2019 was in fact an application for an adjournment made at that hearing, and that the arguments that were put forward were made in support of an adjournment application, in essence a request for some more time so they could be properly ventilated. And we say it is precisely for those reasons that His Honour Judge Hodge was correct in his judgment of paragraphs 81 to 86, it's page 194 of the core bundle behind tab 17. In particular, sorry, I should start earlier than that. Paragraph 74 on page 192, His Honour Judge Hodge correctly noted that when dealing with the argument on abuse of process, in my judgment, important to note the limited nature of the application and argument that was before the court on the 8th of November 2019. Scope and argument came from Mr. Clarkson, sought an order adjourning the application. Now, that is echoed not only in the note of the hearing, my lord and my lady, which you've already indicated you've been to, but also when one looks at the judgment of His Honour Judge Hodge. The vast majority of what he was dealing with was the question about whether or not he should be putting matters off to a later date, that date being after the return date of the freezing injunction. And what we say is that given the limited nature of what was being put forward by Ms. Renata Coates on that occasion, this was not, it could have been put, but it did not need to be put. And I think this is...
But don't you have to say, well, the judge, you have to say the judge was wrong to grant the adjournment, or rather not to grant the adjournment, because you could have appealed against that, could you not? You could have said, well, the judge should not have granted this adjournment, because look, we've got all these defences. We were stifled. There's money laundering going on. They've got unclean hands and all the rest of it. And that would have prevented the judge, would it not, from enforcing the Tomlin order.
Well, my lord, as long as we've been able to obtain a stay at the same time, because he enforced the Tomlin order at the end of that hearing, we would have had to have appealed and also sought a stay. Now, had we done that, yes, that would have prevented the Tomlin order being enforced.
So doesn't it follow that your Part 20 claim now is necessarily an attack, collateral attack, on that order?
Well,
because the ultimate goal is to say this Tomlin order is not enforceable against me.
well, my lord, what we're seeking now is damages. We are not seeking anything else. It's simply damages which operate by way of a set-off. This is in the Part 20 claim. I can take you to the paragraph in the alternative. We have to accept that the properties have now been sold. To which the Tomlin.
Sorry, why does what you're seeking now matter?
Well,
I mean, almost invariably, when people are trying to bring a second claim, which is barred for Henderson reasons, it's a different claim than the one that they tried before, or it's framed differently. I mean, it would be incredibly crude if it was an attempt to do exactly the same thing. So why does it matter?
well,
The question is whether, in essence, what you are now seeking is based, or is an argument, is a claim which you could have made before and should have made before.
my lord, my submission is the second of those, which is the important.
Yes, well, I think you accept you could have made.
We accept that these arguments and the reference to pincer movements have been floating around in witness statements since before the November 19 hearing. But my lord, what we say, our position is simply this, that when Mr. Clarkson came before the court in November 2019, he sought a procedural order. It was nothing more in his argument at that stage than saying, please give me time to run my arguments. And he wasn't given that time. Now, my lord, that is where we could have appealed.
Well, part of the problem, though, is that his draft particulars of claim didn't run that argument.
My lord, no, but had he been given the time, especially the way the arguments had been put, it would have been, for draft particulars of claim to have then gone in which did include the argument, my submission would not have been in any way abusive. They were put before the court as a draft, and a draft only. In essence, saying we have some arguments on conspiracy, not on conspiracy, on unlawful penalties. Now, when one looks at His Honour Judge Hodge's judgment from November 2019, he decides it almost entirely on the standing point. He says, well, you're running an unlawful penalty argument, but because of the effect of the settlement agreement, clauses 6 and 7, you simply don't have standing to do anything. Now, of course, the crux of everything we're saying is we need to roll away the settlement agreement, in short, because that prevents us establishing any claim to be an ultimate beneficial owner. And we have to say, well, we are an ultimate beneficial owner, and all of this has happened to the stuff that we owned. So
you've got to go behind the Tomlin order, haven't you?
Well, but again, my lord, the Tomlin order was limited in its effect. This was not the determination of its enforceability. This was not the court looking at the Tomlin order and saying, is it or is it not enforceable? This was, what happened was, Mr. Clarkson came before the court and said, please can I have an adjournment? The court said no, and in those circumstances...
Well, hang on, you say that, well, in paragraph, if you go to, sorry,
No, my lord, please.
maybe I'm missing it, but page 154 of the bundle for the linked appeals, paragraph 10. I mean, isn't that what was actually going? That's what was actually in front of the court. It's the application to enforce the Tomlin order, lift the stay, enforce it.
My lord, yes. But well, there were two things before the court. There was that application. In response to that application, an application simply for a procedural order for an adjournment for more time.
Yeah, but by definition, if you didn't get the adjournment,
Then everything ran on. I accept that if we didn't get the adjournment, then His Honour Judge Hodge would and did make the order that he did.
And the order itself, page 166, requires Mr. Clarkson to deliver the forms to remove the notices and thereafter take such steps as may be necessary to comply with clause 525 of the settlement. So
Well, yes.
there is an order which is enforcing the settlement terms.
Well, I have to,
And in order to be able to say that Mr. Clarkson is entitled to claim damages on the basis that he is the beneficial owner of whatever the company's called, 10 acres, ultimate beneficial owner, he's got to go behind the settlement agreement.
My lord, he has to go behind the settlement agreement. That's the point of the Part 20 claim is to set aside the settlement agreement and then to claim the damages and run that by way of set-off.
Exactly. So you've got to set aside an agreement which the court has already ordered to be enforced
My lord, yes.
against Mr. Clarkson.
Yes, I have to accept that.
Yeah.
But this is where it comes down to the question in my submission of should. And
you say that's an evaluative judgment for Judge Hodge and we shouldn't interfere with it, essentially.
well, my lord, absolutely. Say His Honour Judge Hodge. It's set out in the. We put the authorities in the bundles, and it's set out in the skeleton arguments. What it is not. It is accepted. It's not a question of discretion for His Honour Judge Hodge. The question is whether he got it right or wrong.
Yeah.
And we say it was but it's a question of judgment nonetheless. And he judged it right. He was the one who was there in November 2019, and also he was the one who was there in February 2021 when this argument was being run. Well, we say that in reality, the fact that this argument wasn't brought on the first possible occasion that it was, and is now only being brought by way of Part 20 claim, does not operate in such a way as to bring it within the Henderson. It's the limited. Again, I go back to it. It's the limited nature of what was being sought and the way that argument was being deployed. Now, my lord,
if you'd have got your adjournment, what would you have then put in, and then what application would you then, on the adjourned hearing, have made to the judge?
So, my lord,
suppose you'd been given as much time as you needed.
Yeah. Well, I think
you come back in front of the judge,
yeah,
facing the application to enforce the terms of the settlement and the Tomlin order. So, what is the application or the argument you would have then made?
Well, my lord, at that stage, dealing in hypotheticals, and I wasn't instructed counsel at the time, but assuming this argument the adjournment had been granted to allow us to run the arguments not only about pincer movements,
well, to run exactly the arguments you're now running in the Part 20 claim.
We are now running.
In other words, challenging the settlement agreement and seeking to have it set aside.
Indeed, then we would have come back before the court
and
adjourned.
So, I mean, when the judge at paragraph 82 of his judgment, Judge Hodge, says that Mr. Clarkson challenged the application to enforce solely on the basis that he said of the penalties, he was mounting no challenge to have the settlement agreement set aside. I mean, he may be technically right that you didn't, as it were, say that on the hearing when you were seeking an adjournment, but that's what the purpose of the adjournment was.
Well, my lord, the purpose of the adjournment, indeed, was to challenge was to give us the time to challenge the settlement agreement properly. Now, I accept that when one looks back at it, the draft particulars of claim don't include the conspiracy allegations. They only deal in terms of the unlawful penalties position. But obviously, we would say that a properly pleaded position claim at that stage would have brought that claim, could have brought that claim at that stage, and then at a later here at the adjournment, to go back to your original.
Or would have made the claim. Would have, in fact, made precisely the same claims as you're now making in the Part 20 claim.
But my lord, the point is we've not had the chance to bring those claims before, or we have had the chance, but we haven't needed to bring those claims before. This is not a situation where, I mean, ultimately the touchstone of Henderson is it abusive? Is what we are doing in some way vexatious?
But if you had brought the claims, you would have maintained your unilateral notices, which you were ordered to remove.
Well, on the hypothetical that we then go to the next hearing,
yeah,
and say, well, we've now got our claims, and you need to stay this claim pending the outcome of our Part 20 claim.
So the judge makes an order which you don't appeal, and you now want to bring the claims that, in effect, would have resulted in a different conclusion from that which the judge reached, which you didn't appeal. Why isn't that a collateral attack?
Well, my lord, my answer to that, the only answer I have to that, is that we are not we are now. We are not actually attacking the decision of His Honour Judge Hodge and the order that he made at that stage. What has happened and what flowed from that order, the removal of the notices, the sale, etc., has passed. However, what remains is Mr. Clarkson's, the fact that Mr. Clarkson has, we say, been the victim of a conspiracy against him, which has caused him loss and damage.
But look at the loss and damage. What he says is, if you hadn't conspired against me, I'd have kept this property. Not only would I have kept it, but I wouldn't have sold it, or if I had sold it, it would have been at a much higher price than you sold it for. And all that is triggered by Mr. Clarkson having been told to remove his unilateral notices. None of this would have happened if Mr. Clarkson had managed to maintain his unilateral notices at the Land Registry.
My Lord, yes, but in terms of whether what we are now seeking to do is abusive, Mr. Clarkson may well have prevented a loss that he has suffered by taking those steps earlier. But in my submission, he is not being abusive by now saying to the court, by way of the Part 20 claim, right, I actually have a defence here. This is operating as a defensive set-off. It's called a counterclaim, but it only operates as a defence.
I understand.
And Mr. Clarkson is not being, in my submission, abusive by coming back before the court and saying, that shouldn't have happened, and it did. But the correct answer is I was the victim of a conspiracy. I shouldn't be paying these sums out because I have a set-off which meets them, and as a result. And so we say it's, again, the touchstone, it's set out in Johnson and Gore Wood, modern restatement. I'm sure my lords you know it far better than I do, my lady you know it far better than I do. It is the question of whether or not this is abusive or vexatious. Yeah. And in my submission, we simply aren't in that territory.
Understand.
Just because His Honour Judge Hodge made an earlier order which we didn't appeal doesn't take us into an abusive situation when we come back around and bring it for a claim for the first time. Unless there's anything else I can assist.
Well, I wonder if you could help me to identify in paragraphs 81 to 84 of the judge's judgment, what are his reasons for saying several times that it's not an abuse? He keeps saying he doesn't think it's an abuse, but what are his reasons for saying that? Can you identify those?
Well, my lord, this was where I took you at the beginning of my submissions back to paragraph 74, my lady. Paragraph 74.
That's the only reason, is it?
Well, he says it's the limited nature of the application at 74. I accept that at 81 to 86 it becomes somewhat circular at times, and there's a degree of repetition.
So he says many times that he doesn't think it's an abuse, but I'm just puzzling over why he says that. But I have your point that at 74, that he says, well, all Mr. Clarkson was doing last time was asking for an adjournment.
My lord, yes. Well, in 82, a point you've already, either my learned friend made or I was taken to from the bench, he mentions the fact that there was no challenge at the earlier agreement to have the settlement set aside. So that's another factor which I suppose links to the narrow nature of what was before the court on the last occasion.
Yeah. Although it doesn't, it's really not the whole story, is it? Because the reason he was being asked to grant an adjournment was precisely to enable a challenge to take place to the settlement agreement.
My lord, yes. I accept that was...
I mean, so in essence you're trying to rely upon the fact that you weren't able, by reason of a decision not to adjourn, to mount the challenge you wanted to adjourn, but you didn't appeal the refusal of the adjournment and the making of the order on that occasion.
I accept Mr. Clarkson didn't appeal at that stage. Yeah. But the point I was trying to make earlier is that simply now confronted with a claim where Mr. Clarkson has a claim which has never been ventilated before the court, and I accept we're in Henderson not res judicata territory, so that's not necessarily a complete answer. Yeah. But in circumstances where this is the first time this has actually been ventilated in any pleading at all, and in circumstances where it's going to operate in a different way, he's not seeking to run this, to rescind anything and to get properties back. That ship, unfortunately, has sailed. But he's now running the argument, the remedy, as I mentioned earlier, now is a damages remedy to run as a settle. So I accept we didn't challenge, but it's again, in my submission, it all comes back to the touchstone of what is abusive. And my lords, in my submission, it's not abusive in these circumstances.
Yeah.
In terms of the reasoning, it really is. It's paragraph 74.
74. Yeah.
Para 82, and there's little else to pull out of those.
Yes. Anything more, Mr. Bowes?
My lord, no. The only other point, perhaps, is in 84.
84.
Between the hole punches, we have, I see no reason why Mr. Clarkson should be prevented from raising that case. Now I do not consider he is misusing or abusing the court's process. The judge clearly had the test in mind. Sorry, it says that he is not misusing or abusing the court's process by raising this challenge to the settlement agreement now, having failed to do so in November 2019. That is probably those are probably the three points where we take a reason out of the judgment, out of many paragraphs. So unless there's anything further, my lord, my lady.
Thank you very much, Mr. Bowes. Mr. Buck, do you wish to reply?
Very shortly, my lord,
Yes.
my lady, just one point, and that's to draw the court's attention to paragraph 54
Of the judgment.
of Judge Hodge's judgment from February 2021.
54 of the current judgment.
Yes, my lord, page 188.
Yes.
Where His Honour sets out very precisely what he held.
Yeah.
Unless I can assist further. Unless I can assist further on that point.
I mean, you want paragraph 53 as well, I think, don't you, just for completeness?
Yes, my lord.
Yeah. Yes, all right, thank you, Mr. Buck. Well, we're going to rise for a few minutes just to take stock of where we are. Don't go away. did say don't go away, Mr. Buck.
I do apologise. I'm just aware that those instructing me wanted to have a quick word, and it was live streamed, and I'm aware it isn't.
Right. As far as the abuse appeal is concerned, we are of the clear view that the Part 20 claim is an abuse, and we will give reasons for that in writing. In the light of that, as at present advised, we see no need to hear argument on the adequacy of the pleading of the conspiracy claim unless one or both of you seeks to persuade us otherwise.
No, my lord.
My lord, no.
Right. Well, in that case, we will reserve our judgments on the admissions interest and the abuse points. You will get drafts in the usual way, your opportunity to correct our English but not our reasoning and not to raise new points. We would hope that in the light of the draft judgments you will be able to agree in order disposing of the various appeals. If you can't agree an order, please make short submissions in writing and we will make the order that we consider to be appropriate. Well, thank you both very much for very succinct arguments, but the points I think have been canvassed and we will go away and think about them. Thank you very much.
Right.